I'm Nicholas Bartson, founder of Altus Legal, a firm devoted to representation of condos and HOA associations in Illinois, as well as delivering legal services to those associations. Disclaimer here, I'm an attorney licensed to practice in the state of Illinois, but I'm not your attorney nor necessarily your association's attorney. This video is made for informational purposes only, does not create an attorney-client relationship, and should not be seen as legal advice. You should consult with your own attorney before relying on any of this information. Okay, today we're going to talk about marijuana in community associations in Illinois. There are now 8 states permitting recreational marijuana use, and that number continues to grow. Medical marijuana is already legal in the land of Lincoln, and the state legislature is already considering legalizing recreational marijuana use as well. So, as the use of pot in associations and in states continues to spread like weed, bad joke, how are boards supposed to deal with regulating the use in an association, with one side claiming the medical need for use of that marijuana, or, in the case of a recreational use, if it becomes legal, their right to use something recreationally, and other unit owners claiming nuisance or secondhand smoke concerns. Well, the good news for boards is that while medical cannabis at this point is not criminalized in Illinois, that does not mean that owners within association can use their medical use card to flout the association's rules that prohibit noxious or offensive activity. Medical marijuana, or any kind of marijuana, is pungent and the smoke can be very bothersome, especially if it's seeping into the adjacent units or common element hallways. It does not matter if the unit owner smoking is doing so for legitimate medical reasons. If the smoke is leaching into the hallways or neighboring units, the board has a duty to act. Secondhand smoke risks for marijuana are the same as those for tobacco. Heart disease, lung cancer, asthma in children, myriad other health risks. All smoking by combustion has the potential to create a nuisance for other occupants of an association. So what's the solution, the board might ask? Well, the board generally has 4 options to limit marijuana smoke from causing problems for other unit owners without hurting those who have a legitimate medical need to use it. Those 4 options are as follows. Number 1, illegality. The association's declaration no doubt prohibits anyone from doing anything illegal within the association. In Illinois, the Medical Cannabis Act prohibits smoking anywhere where it can be reasonably observed by others or in close proximity to anyone under the age of 18. This means that anybody smoking pot in the common elements or around the patio, pool, or even balconies could be violating the Medical Cannabis Act as well as the declaration to boot. Case in point, it has to stay behind closed doors of a unit in order to remain legal within the state of Illinois. Number 2, a smoke-free building amendment. The association can consider amending the declaration or bylaws to prohibit all smoking, both in units and the common elements, without violating the rights of any medical marijuana user. Now granted, amending the deck to limit smoking within units can be a tough row to hoe, as you'll need buy-in from generally 67 to 75% of the unit owners, depending on what your declaration calls for. Doing so, however, will not affect the users with a medical need, as there are myriad other ways to get high without traditional smoking via combustion. Medical marijuana users can purchase edibles, which is cannabis-infused food or other products. They can get topical ointments laced with THC, or use vaporization to ingest marijuana, which heats the marijuana to a high temperature and eliminates the combustion smoke. So again, the smoke-free building amendment, while it's done in some cases, does require unit owner buy-in and can be more difficult. Number 3, simply relying on the use and occupancy provisions already contained in the association's governing documents. Most declarations prohibit noxious and offensive activity, which can certainly include smoke seeping into units or hallways. The board can treat marijuana smoke, even medical marijuana, leaching into common elements or other units exactly as it would Sunday morning construction, or rowdy guests in the hallway, or a blaring television disturbing other residents at night. It can issue a violation and force that smoker to get high in a more communal and neighborly fashion without bothering the other unit owners, the same way the board would limit an individual from watching his or her television too loudly or having guests over that disturb other people. And the 4th option is the board unilaterally adopting a smoke transition rule. So unlike option 2, which was a complete smoking ban via a declaration or bylaw amendment and required unit owner buy-in and approval, the Illinois Condo Act allows board to adopt rules without unit owner approval. The board could simply pass a rule requiring smokers, both tobacco and marijuana, to mitigate the transmission or exfiltration of smoke via certain techniques from their units, which could include sealing their unit with caulk around the baseboards or the outlets, using an air filtration system or smokeless ashtrays, or limiting their smoking to one particular room within the unit where it's less likely to bother others. The violation of this rule would allow the board to fine the smoker, which could have the effect of keeping him or her in line. So in sum, the board is able to balance the demands of both the anti-marijuana contingent of unit owner and occupants with those unit owner and occupants who have a legal right to use cannabis in their home without feeling any harassment. If the individual smoking pot is not doing anything illegal or violating the declaration or rules or really bothering anyone else, the board should leave the matter alone, as harassing an owner may expose the board to some liability. But the board has a fiduciary duty to uphold the declaration and bylaws, and that would include prohibiting any violations or nuisance, noxious, or offensive activity from going on in the association. So in short, to conclude, the board should not be scared by the fact that the individual has a medical marijuana need. If that person is violating the declaration or bothering other people, the board has a duty and has the legal obligation to stop that behavior. Thanks a lot for watching. If you want more information on issuing violation notices or otherwise, go ahead and look at the Altus Legal website or contact me. Thanks very much.